I'm not sure, because I was told when I asked how sophisticated the crowd was. Not sophisticated, that's not true, but I mean, how much knowledge did everyone have about crypto in general? And I was told to stick with the basics. And so, you've already heard who I am. I'm a 20-year big law veteran who is now in-house at ShapeShift. And I have been dealing with, because I was a payments lawyer for so long, I started hearing about Bitcoin in particular really early in the game because it was a payment method. And my job involved many times educating folks at the American Bar Association or at my law firm or counseling clients on the very newest cutting edge technology with regard to payments. So, so this is a quick rundown of Bitcoin in general, because I asked, should I start at the beginning, and was told yes. But I think most of you have already heard this stuff or already know it. But in any case, there's just some really highlights on Bitcoin in particular, because it was the very first one and most well known. And then blockchain technology at the bottom there. But I think you guys already know this stuff, so I'm going to skip on. So my job, mostly through most of my career, has been counseling companies on regulatory matters with regard to moving money from person to person or place to place. In the case of cryptocurrency, it's not money, but many regulators would like to think it is. And so what I'm going to do here is give you guys an overview of what the various federal and state regulatory agencies actually do and how that might apply to a crypto company. So first, at the federal level, because we start there, there are a number of organizations and agencies at the federal level that regulate money and money substitutes. So the Federal Reserve, we know, it's a central bank. They set monetary policy. They are concerned with cryptocurrency because they are concerned about disrupting their existing system of monetary policy. So they so far haven't really weighed in on the subject, but I wouldn't be surprised if they did. FinCEN is a division of Treasury. They are in charge of combating money laundering and financing of terrorism in particular, but other crimes as well. And the CFTC is the Commodities and Futures Trading Commission, and they regulate futures and options and related things like that. Some folks have developed derivatives and some other futures and swaps around crypto, and so therefore they will be regulated by the CFTC. The SEC regulates capital markets. That should be an S, not just a single market. They regulate the capital markets in general. OFAC is the Office of Foreign Asset Control. They regulate transactions with sanctioned countries and persons. I have the CFTC on here twice. That's weird. So, okay, that's why the spacing is goofy. They're on there twice. That's not something I caught. Anyway, the OCC is the primary regulator for national banks. National banks are Wells Fargo, Capital One, that sort of thing. One of the first places to start is how crypto would be classified, because once you know how it's going to be classified, maybe then you can decide which federal agency you're going to have to pay attention to. However, in this case, many regulatory agencies have decided to classify crypto in their own way. The CFTC has decided it's a commodity. The SEC has decided in many cases it's a security. FinCEN has determined it's a currency, and the IRS has decided it's property. So that can make compliance pretty difficult when you can't just say, oh, well, this is this thing. It's a security, therefore I only have to comply with what the SEC has to say about it. Not true in crypto, because all of these agencies have their own opinion. So we are the servant of many masters. Let's start with FinCEN. FinCEN, that's interesting. There's something going on with formatting here. I can't explain what. FinCEN initially got into the game pretty early. In '99, they published a rule and some regs about implementing the Bank Secrecy Act that provided the framework for the later things they would do. And then in 2011, they they amended one of the definitions of money services businesses to include money transmitters, and though the money transmitter definition is where crypto often finds itself, because it basically is essentially receiving money for the purpose of transmitting it onward. So if you're receiving money, and in this case we're going to consider crypto money even though it's not money, this is how the FinCEN's going to look at it. If you receive it, sit in the middle, for example, and you move it, you receive it, and then you pass it on, that makes you a money transmitter. Think of Western Union or MoneyGram or PayPal. 2013, FinCEN issued interpretive guidance to clarify the applicability of the Bank Secrecy Act's regs to determine who was actually going to be covered. If you were just a user of the cryptocurrency, you weren't going to be covered. If you were just investing in it or mining it for your own use, you weren't going to be covered as an MSB. Some administrative rulings came in 2014, clarifying some of those things. If you're just purchasing it, like I said, a couple of things you could do with it. But if you were actually serving as an exchange, like a Coinbase, then you were going to be covered by the Bank Secrecy Act, and you'll be covered as an MSB, a money services business. So in 2019, so this is very interesting, this is not fitting onto the page. In 2019, FinCEN issued their guidance on crypto assets. All that was really was a collection of all of the things they had done before, plus a few more things, but nothing really new, nothing particularly useful, just sort of all in one place. And I'm wondering if I should ask if we can make this smaller. It's not fitting.
That's going to be tricky within PowerPoint right now.
Okay, never mind. We're going to power through. Okay, so if it turns out that FinCEN determines you are an MSB, a money services business, what can you expect? You can expect that you're going to have to register as an MSB with FinCEN, which in and of itself is not a big deal because it's just a registration. You fill out a form and pay a little filing fee, everybody's happy. But you might then get letters from state regulators who will have noticed that suddenly you've declared yourself to be an MSB at the federal level, and so maybe that means you're also a money transmitter at the state level. And as you may have heard, we have a bunch of states. So we'll talk about that later, but that can complicate things. Once you're registered as an MSB, you're expected to promote a culture of compliance at the company, which means everyone has to be on board with whatever you put in place and enthusiastic. You have to designate an officer to oversee that stuff. You have to develop a risk-based anti-money laundering policy and procedure. An anti-money laundering policy will include a know your customer component where you have to collect names, addresses, pieces of social security numbers, the whole thing, or just a truncated version of it, date of birth. You have to put in a transaction monitoring system or some other system where you can spot certain characteristics of people that are trying to launder money. That would be things like structuring of transactions so that they don't hit certain thresholds that will trigger an alert. That you have to pick up on that. You have to pick up on the velocity of transactions that someone might be making, and who they're transacting with. And you will then have to file suspicious activity reports. If some transactions or a set of transactions catches your eye, then you have to file a suspicious activity report with Treasury. There are detailed requirements at fincen.gov, but essentially it takes a huge component of the initial intention of crypto, which is anonymity, out of the mix. Because while once you're inside and you have cryptocurrency and you're going to use it to buy things, in many cases that's anonymous, but going in and out of the system in an exchange, you're then turning over a lot of your personal information, so it can be monitored and your transactions can be gone through an AML policy. Many people find that very distasteful, but that's where we're at right now if you fall into the category of money services business as defined by FinCEN. There's a lot that they don't say, and there's a lot of things that various companies are doing that I personally believe fall outside of the definition of MSB. If you're not taking custody of someone's assets, you're not sitting in the middle between parties, there's a lot of things you can do to sort of de-risk the possibility that it would be considered an MSB. But none of it is foolproof because FinCEN has kept a very, sort of loosey-goosey definition of who they're going to enforce against and who they're going to rope into their scheme. The next party to be interested in is the Securities and Exchange Commission, because, as you may recall, back in 2016, 2017, there were a lot of initial coin offerings, they were called at first, and then there have been a couple other names for them, but for brevity, we'll just call them ICOs. There was kind of a gold rush. People were issuing these coins or tokens in exchange for money. They were basically trying to raise money to get their projects going. The SEC took notice because those tokens in many cases resembled shares of an equity in these companies or projects, and so the SEC decided, well, they should be regulated as such. And so, because they'd never seen something like this before, they did a little investigating. They came up with the Dow Investigative Report in July of 2017, which was the initial roadmap. But there was no enforcement action against Dow, which was one of the projects. It was just an investigative report, which was meant to serve as sort of a warning shot to anybody else in the ICO business that, hey, we're taking a look at this stuff, and here's what you're going to need to pay attention to. In the Dow report, digital assets, the tokens or coins, were analyzed according to the Howey test. Howey test was set forth in a case decades earlier, but it was what the SEC had to go on. The sort of recurring theme here is that these agencies are trying to cram brand new technology into, in many cases, really old legal framework, because it's all they've got. It's all they have to use, and so therefore, that's what they're using. So the Howey test set out 4 factors required for a digital asset to be an investment contract and therefore a security and subject to securities laws. The first is an investment of money. The second factor is a common enterprise, like a company. The third is a reasonable expectation of profit. If you invest in our ICO, then once our project is up and running, you'll get a cut of the upside. And 4, derived from the efforts of others, meaning, the folks at the company are going to, the project, whatever it is, they're going to be creating this thing, and you'll get a cut of the upside, like I said, but it's the efforts of others. So that was the initial volley from the SEC as to what you needed to look out for. If you want to avoid regulation, then you avoid those 4 factors. You have to have all 4. You can't. In order to be a security, most folks wanted to avoid having their tokens deemed as a security because that required they be regulated as broker-dealers under the SEC's licensing scheme. And additionally, and this is another example of how you can't just pick one regulator, depending on how the money was flowing in and out of your ICO, they could be subject to FinCEN regs too, from the prior agency we discussed. That's interesting. Here we go. So the sort of exemption under the SEC's ICO scheme is if you were instead issuing what they were calling utility tokens. They don't really use the term, they used it initially, but then they stopped using it. But that's basically indicating a token that grants you some sort of right to utilize the project for certain services. And if you're issuing a true utility token, you won't find it regulated by the SEC. And these are the characteristics. They are the network and the token are developed and usable for certain intended functionality. The marketing is focused on that functionality and not focused on giving you a cut of the upside. That is to say, potential appreciation. Not focusing on the fact that the token will be worth more in time. The tokens are designed to meet the needs of users in the service that's being developed, and there is a direct correlation between the price of the tokens and the price of the services that the tokens can be redeemed for. So if you are able to design your ICO to have tokens that look like this, then you're less likely to be regulated by the SEC, which, most would consider a good thing. After the initial volley with the Howey test, there were a few other things that we've had to cobble together to try and get some guidance on how the SEC is going to view ICOs or in general digital assets. And so, we start looking at the director's speeches and other things, any public speeches that are made, any private conversations, anything, lawyers in the industry started kind of clinging to get more guidance because there wasn't actual guidance. So he suggested these things, that tokens sold as securities could later shed that designation if they became sufficiently decentralized. And if you focus on the final two factors of the Howey test, which, as we may recall, are reasonable expectation of profit and derived from the efforts of others, then if you stay away from those, then you might be able to shed that designation. And they asked a bunch of questions for direct analysis, and then his comments are not the opinion of the SEC as a whole, but they're noteworthy just the same. Like, we have to, as I said, without guidance, in absence of actual black and white guidance, you have to look at what you got. This was one of the things we got. Then there were some enforcement actions, other things to pay attention to. There was some of the initial ones were against Paragon and Air Token, which solidified the focus on the last two Howey test factors, the efforts of others, and the expectation of profit. And they were initially, the SEC, going after the most scammy looking stuff, right? So that's how the agencies tend to do it. They don't go right for the people that look like they're good actors, but maybe, failed to disclose something. They go for the really obviously scammy stuff. And in this case, these were their first two. Let's see, then there was a no action letter that came earlier this year with regard to sort of a token for using jets. It was a no action letter by the SEC. It was the first one they issued. All that means, though, is that they weren't taking action against that particular company. When this letter came out, we all read it with great interest because we were hoping for some actual guidance from the SEC, but in fact what we got was, yeah, this applies only to this particular set of facts, and we're just not taking an action. Doesn't mean we have analyzed their actual offering. It just means we've decided not to take action on this. So don't assume that it's going to apply to you, all that stuff. So that's what a no action letter basically means, but everyone was hoping for more substantive analysis than we actually got. And then they released an investment contract analysis. I've sort of gone over that stuff, but essentially by the time we take the Howey case, the Hinman speech, the enforcement actions, and a few other things, we ended up with essentially 50 characteristics to evaluate any particular token to determine whether or not it was going to be deemed to be a security, which is very confusing and hard to, get much out of. So, one of the latest things is Kik. You might have heard this. Kik Interactive was a messaging app. They actually goaded the SEC into suing them because they said they themselves were going to sue the SEC, and they spent a bunch of money and got a bunch of notoriety for forming a fund for that. And finally, the SEC said, fine, we'll sue you. So they sued them for unregistered sale of securities because Kik was basically marketing the tokens as an investment opportunity, and that the company execs were experts and they could increase the value of the tokens and the demand for the tokens over time. And so we're waiting to find out what happens with this case. There's going to be a jury trial, maybe. I mean, one was demanded. We'll see if it settles, but it will be a closely watched case. So the SEC is full of landmines, and all federal agencies tend to be that way. But this one is particularly sort of hard to pull together. So the key takeaways for the SEC are right here. Constantly changing regulatory environment, absolutely true. Not just true at the SEC, true a lot of places. So they haven't been very clear or consistent. And companies basically have to constantly check in, see what's the latest thing that's happening with the SEC. Costs a lot to ensure compliance. You have to review if you're listing assets on an exchange or any kind of platform, you're going to have to review them very carefully to make sure you're not accidentally listing something that will be deemed to be a security, and therefore you will actually need to go get yourself a broker-dealer license just because you didn't carefully vet the assets you're listing. Because of that, new and emerging companies with limited resources are going to have a harder time competing on this particular platform. And Commissioner Hester Pierce, who is very popular in the sort of crypto community because she has essentially said, we are not giving anyone enough of a roadmap. And she has given several very public speeches about her concerns that this can create, the way that they're doing creates a competitive disadvantage and it stifles innovation. So she's out there sort of making the same case I'm making, which is the SEC is not giving us enough clear guidance for us to really be able to, take a black and white look at something. Next federal agency is the Office of Foreign Asset Control. This is one people don't think about very often. OFAC is basically in charge of making sure that not just financial services companies, not just corporations, but actually anybody technically is subject to coverage by the OFAC. You as a human being, individual, are not allowed to transact with anyone from a sanctioned country. That's Iran, North Korea, Syria. There's a list. And there's also a specially designated nationals list, which are the people deemed to be bad guys by OFAC that you need to that is constantly updated because people fall in and out of favor. And so you need to keep track of the SDN list and the sanctioned countries. It applies to everyone, not just like companies. And it is strict liability, meaning you can't just say, hey, listen, I only transacted with 3 North Korean companies or I didn't know, or it was just a little amount. That's a strict liability. So essentially, you kind of have to know about this one. Criminal penalties are steep. Fines, $1 million, 20 years in prison for each violation. That's up to. So it's like up to $1 million. I've never seen the max penalty be given out. But you have to pay attention because each violation can start to add up when you're doing a lot of transactions. The good news, the very good news, is that compliance with OFAC is the sort of thing that you can get done by a third-party vendor. It's automated. You don't have to take every transaction and look at it and read who they're transacting with and try and sort that out, especially when you're dealing with long wallet addresses. Then you can automate this. There's a number of companies. So it's something that's doable, but it is something that has to be done. This one is not a lot of gray area there. Everyone's covered. And the CFTC. Finally, the CFTC. The CFTC actually was one of the first regulators to look at crypto, and they've been pretty willing to be adaptive. They're pretty open-minded about it. They issued warnings early on about the public about scams. Like most of the agencies did. In fact, most of the countries in the world did initially, about, beware of scams. They, however, have a process to review crypto offerings for their own issues. They've issued licenses to certain crypto projects offering, doing, exchanges for derivatives and things like that. And they actually do appear to want to foster innovation. So the CFTC is pretty reasonable in the grand scheme of things, and they've issued pretty clear guidance as well. So we're happy with the CFTC. The states, look how many states. And the thing about the state laws is that once you sort of figure out how to deal with the federal laws, you have to turn to the states. And if you have users in, pick a state, you have to follow those state laws with regard to users, because the state laws are more like consumer protection laws. These laws, are there to protect consumers from, bad actors. You have to be licensed if you fall into the category of a money transmitter, which is usually defined as receiving money for the purpose of transmitting it onward. Then you will have to get licensed in that state. So as I say here, states are concerned with consumer protection. Feds tended to focus more on the anti-money laundering and financial system issues. States, however, are relying on very, very old, like Civil War era money transmitter laws designed for a physical world. So a physical human will walk into a physical place and see another physical person, hand them physical money. That physical person puts it in a physical drawer and then sends a message to another physical person in another place to pull physical money out of their drawer and hand it over to a recipient. That was what these laws were designed for. So you can imagine they've had to develop over the last few decades and account for electronic movement of money initially, and then now electronic movement of other types of assets. And so many states are incredibly slow to adapt or figure out how, if they want to regulate. So what we end up is we have some states like New York, and there's a few other states that have special licenses for crypto. Then there are other states that are just expanding their existing money transmitter laws to include crypto. And then there's some states that don't care, or they might care, but they're not going to go investigate. And so they kind of turn it, like if you were to ask them, they'd say, yeah, sure, we'll regulate you. But if you don't ask them, they probably won't talk to you. And so keeping track of all those states is another thing that one needs to do, and sort of figure out, does my model fit within this? And generally speaking, if you're receiving money and you're sitting in the middle and you're there sending it on to someone else, that is kind of the textbook definition of money transmitter. There are a lot of workarounds, and we'll get to those in a second. So this is the first half, or the first part of this program is, look how scary. And then the second part will be, oh, by the way, you can deal with this. So this is the, oh, look how scary the states are. I'm from the Bay Area, and so, and I've been practicing with startups since basically my whole career. Now, if you take a look, these are walls at Facebook. These are the messages you get all the time. Fail harder, think wrong, move fast and break things. These are the general philosophies of startups in where I'm from, and startups in general. Not the walls of a bank. You won't find these on the walls of a bank at all. They do not move fast. They will break things, but they don't move fast. And and when they fail, sometimes we bail them out. But there's a very huge difference between the mind of your typical startup cowboy and an institutional bank. Finding innovative banks is a really great and rare thing, and they do exist, but there's not enough of them. So I'm showing you this because what I'm about to talk to you about is working with banks. And these are also things, just because I find these quotes to be great, heard around the valley, but essentially in any startup environment. These are some of the early ones, right? I personally like starting at companies like jumping off a cliff and assembling an airplane on the way down. That's one of my favorites. Also, today's creepy is tomorrow's necessity. Definitely comes up in the crypto world. And then, of course, don't be evil, which is the Google founding philosophy, which I think we can all agree they have grown out of. We're going to say grown out of. Those are just some of the philosophies that folks that are super innovative, cutting edge, or at least were once, have said. Now let's talk about how to deal with some of the stuff that I've just given you sort of the scary picture of. That's been me many times. When you're this is a presentation to lawyers, although most of my colleagues over here are not lawyers. One of the things that I have found is crucial to working in a new technology space and working with startups is you have to be innovative. Sure, fair, but everyone around you is innovative. You often have to be the voice of reason when no one wants to hear it. So that can be difficult. So you have to sort of resist being a naysayer, but you have to do your lawyer job, right? Assess the risk, assess the reward, look for workarounds. Don't succumb to pressure. A lot of times you want to bring something, to the business stakeholders, or the marketing folks, or anybody, and say, listen, I need you to put this disclosure here. I need you to, we can't do it quite this way. Can we do this other way? And you'll get pressure. We've worked on this. Or engineers, we worked on this. It's already been coded. Yeah, I'm sorry, but you should have come to me earlier. So one of the things is look for workarounds, and you got to stand your ground. It's not always easy, but when your job is to protect the company from risk, whether you're outside counsel or in-house counsel, you have to definitely stand up for what you think is the thing that needs to happen. Present logical solutions. That is to say, consider all of your possibilities and present the things that are going to still achieve your goals while not screwing up the entire product that someone has spent a long time developing, or the entire philosophy of the company. I mean, if you can do that, that's the thing to do. You got to stay current on all the laws and regs, which is not an easy thing to do, as I just pointed out. They are constantly in flux. And resist this, it's easier to get forgiveness than permission concept, because while that used to work, a lot of companies have been very successful starting like that. PayPal's a notable one of those, where they just sort of launched and then decided to sort of backfill with regulation later. A lot of folks have done that. It's getting harder to do. Because regulators are onto it, for one thing, and secondly, they are developing regulation and guidance around a lot of the things that innovative companies want to do. So, not necessarily true that it's easier to get forgiveness and permission. It is also not necessarily false, but it is not necessarily true. One of the things, because these laws and regs, what they regulate is activity. Right? So they don't regulate that you call yourself a certain thing. They regulate activity. So you have to take a look at what you're doing. I sort of take a look at your model, map it out. Are you touching money? Are you controlling money? Or something that someone could consider money? Like, are you in charge of someone else's asset? Are you touching that? Are you taking custody of it? Are you offering an investment? There's a bunch of different things. You want to take a look at the activities, because that's what's regulated. So you have to pull apart the model in many cases. And those are all regulatory triggers. This is what I mean. Take a look at the entire model. And I would say to my clients, find the holes. What I meant by that was, take a look at your model and you personally use your own brain to figure out, how could I steal money? How could I do that? If I was using my system, how could I use our system to launder money, or scam someone out of money, or mislead, or where could we be hacked? Like, take a look at your whole model and do a flow of funds. That's the way to figure out a lot of this stuff often, is to sort of follow the money. And that would be, starting with the user, and the user sends the money or the asset or the whatever it is to point B, and where does it go from there? And are there any holes where someone who either worked at the company or outside the company, a malfeasor, could steal, reroute, scam, any of those things? It's generally muck it up and cost someone their money or their asset. You look at your whole model. When you find any of those holes, that's what you need to focus on. We can't do this because someone could find their way in, and someone at the company could do this, because that's what the regulators are going to be looking at. They're going to be looking at, well, how do we know that you're not just going to steal Aunt Betty's money she was trying to send to her nephew? You took it in, did you send it back out? And so look at your own model and scrutinize it for the holes. Then take a look at your model and determine if there's a way to work around the regulations. So generally, regulatory lawyers, especially if you're working in fintech, you have to either work through them, which can be time-consuming and costly, or around them. So I used to I would do one of these little sketches, although that's from football or something, but I would map it out even on a napkin, like, show me the flow of funds, and then if we just moved it over here and you didn't put it through this system, you put it over here, could we then avoid you being sort of in the middle and being considered a money transmitter or a lender or whatever it is? And so once you decide whether or not your model can be reworked, and if it can't, you need to decide if you're going to build your own system or buy. By buy, I mean, well, hold on, build. This got reversed. Build would be a build your own compliance solution. If you are going to build a 50-state solution, that's a lot of money. There's a lot of moving parts. There's 40 plus states that offer money transmitter licenses. Each one of those licenses will require a surety bond, an application, obviously, application fees. Very, very invasive and time-consuming personal and financial data from all of your officers and directors and major shareholders. And you have to set up a compliance program for AML and things like that. The good news is that if you already have this at the federal level, then you can, the compliance, that is, the AML stuff, then you can, just use that. The bad news is that to get surety bonds and the licenses and all that takes a long time and costs a lot of money. It can cost, it could take definitely over a year, sometimes 18 months to get the licenses. And depending on your predicted volume, it can cost, way over $1 million. A lot of that will be in surety bond premiums, and some of it will be in legal fees, and some of it will just be in, other fees, fingerprinting and all that stuff, but it adds up. So that's if you want to build it. The good news about building it is that once you've built it, you have expanded your capabilities and you can sort of branch out and offer different products to folks than you initially thought. You can add, it'll be easier for you to roll out new products because you already have this in place. If you want to buy it, meaning you don't want to build it yourself, you want to then basically partner with a bank. That is how you essentially buy compliance. Bank partnerships solve a lot of issues. They also cost money because banks are looking for money these days. And bank regulators are requiring their banks to engage in enhanced due diligence of people in fintech, particularly crypto, or anything with the word blockchain in it. And that can be tricky to find a bank that's willing to partner with you. But if you do, it could be a very beneficial relationship. However, you must understand the culture clash that you'll be getting into. I've got pictures of cowboy riding a dinosaur, and I've got a picture of a dinosaur chasing a cowboy. And the reason is, I used to always, and my bank clients did not appreciate this, refer to the banks as the dinosaurs and the startups as cowboys, because banks are freighted with so much regulation. I mean, all of the stuff that I just went through at the very beginning, banks do that all the time. That is just part of being a bank. So they have a lot of regulation. They're used to it. That's their comfort zone. And the sort of cowboys, entrepreneurs, are specifically trying to disrupt that very thing. So they don't want rules. They're not used to rules, and in some cases don't believe in rules. And so my job, usually when I was working on bank partnerships for clients, was to sort of serve as an interpreter, because I represented banks for a long time, then I represented startups for a long time, and the culture clash was, it was one of the hardest things. Banks are used to getting whatever they ask for. Sometimes they ask for things they're not technically entitled to, and there are places you can push back. So you kind of have to understand where you can push back and say, no, I'm not going to give you that. You don't really need it, and you're not entitled to it, and I don't want to give it to you. So you end up with power struggles a lot of time, and who's really in charge. But again, all of that said, it's a quicker route than trying to build it yourself. And sometimes you want to start with a bank partnership, and then while you build your own system when you build it on your own. So I've just spit out a lot of stuff. There's also miscellaneous, regular, just any sort of financial services, miscellaneous stuff you'll have to deal with. Disclosure issues, as in, I show these tiny little things because many cases you'll have disclosures you have to make that are really long, but you have, a postage stamp size to make them on. So those are things to consider. unfair deceptive acts and practices, which is essentially don't mislead people, don't promise things you can't deliver, don't steal, don't scam. All of those are privacy, data security, obviously, and then if you're going to be international, there's a whole other set of things. This talk only covered a very high level of US law and regulation. So I left room for questions because I've been talking very quickly and going through a lot of stuff, but I don't know if anyone has questions or not. Yeah?
What would be your approach? So I work for an association in Florida, and one of the problems we're always having is we can't get banks to bank crypto or
Right.
blockchain companies.
Right.
We had a lawyer who's just a blockchain lawyer, and Chase Bank shut down his bank
Yeah.
account, even though he doesn't even accept crypto or anything. And in the state of Florida, we've talked to our CFO in the Office of Financial Regulation. Banks can bank these companies.
Mm-hmm.
There's no worry about compliance. They have to know how. They just choose not to.
Exactly.
And so, we're trying to talk to like the government offices to issue some kind of edict or whatever, saying it's okay to bank these companies. But it almost seems, and obviously I would never tell the banking associations that I work with this, but it seems like it's more just on purpose. Specifically, it's squelching competition. So how do you deal with a scenario like that when there's apparently no legislative solution? Because even if the banks know, the banks are educated. I feel like the banks that I talk to, they know the benefit, but they just don't know to plan.
It depends on your model. I've certainly encountered a lot of banks that have just said, we're just not going to bank blockchain companies. Like blockchain, that's a massive net. That's a lot of companies that you're cutting out of your universe. Crypto is much narrower, and ostensibly more risky, or perceived as more risky. But it is because of the enhanced due diligence that the higher up, the OCC, Office of the Comptroller of the Currency, the FDIC, and Treasury, and a bunch of influencers of banks and regulators of banks have said you need to take extra precautions, and here are the extra precautions. What you're saying is they're unwilling to do that, and you think it's because this industry is creating competition for them. Not completely outlandish concept, that. I have, if you want to talk afterwards, I can give you some names of banks that have sort of are willing to take a little bit of risk, and their perceived risk, not actual risk necessarily, but and are more innovative. You can't sort of. It'd be strange to be like an anti-discrimination law is what you're looking for. I'm not sure Florida is going to be your best bet for that. Right, and a state like Wyoming is looking to get more industry into the state because it's not New York, and so it's an interesting idea. I would say it's probably on the list of priorities for legislators right now. Probably not that high. So there are lobbying and advocacy groups. Obviously, you're probably part of some of them. Not super powerful yet. I say yet because I think obviously this is an industry that's really kind of in its infancy. Even there people here who've been involved in it for years and years, that's still really an industry in its infancy. And so legislators will. Once they perceive a power shift or even a power surge in this industry, they'll start paying more attention. But in the meantime, I will give you some names after this if you want, if you need to try to bank. Happy to. Anybody else? Ooh, I answered all of your legal questions. I'm just that good. I answered all the legal questions.
I have another question.
Go for it.
When you were talking about the banking FinCEN,
Mm-hmm.
why did they issue in 2011? What made them issue those money service business acts? Like why in 2011 what was the motive?
Oh, it was virtual currencies. So what they did was they expanded the there's like the prepaid card. There's a prepaid card definition or prepaid value and stored value. There's like this whole mishmash of definitions. And what they did was they just expanded one of their existing rules to include a concept of convertible virtual currency, and it was to account for things like e-gold and Bitcoin and things like that. And so what they did at first, because they thought it was just going to go away, but they wanted to, have some sort of coverage there, they just expanded the rule to include convertible virtual currencies and a couple other things. And convertible virtual currencies would include something that's convertible to fiat currency, but it wouldn't include something that isn't convertible to fiat currency, like a Starbucks card or something like that. So it was the development of the new technologies that caused them to do that. But it was a very small measure. It had a bigger impact, but it didn't take them much to do it because they had an existing scheme in place and they just plugged in a new definition. Okay.